Right, yeah, cool. Yeah, welcome everyone. Oh, YouTube's telling me to do some stuff that it doesn't normally do. So, yeah, welcome everyone. If you're new here, this is our weekly live stream on this channel. We are doing a weekly live stream on Will's channel as well, just to kind of increase the capacity. Usual stuff applies. Please don't put personal data into the live stream chat. I will delete it. I'll try and be nice about it, but I will delete it. Ask your questions as if they're about someone else. You'll get a better answer in most cases. Yeah, you won't get a worse answer anyway, because it helps us identify what the actual issues are. And what else do you need to know? The usual sort of thing. We're going to go through a bunch of questions that have come into the channel. There's some interesting ones this week, actually. And once we've done the ones which are anonymized, we'll then get into the live stream. And then once we've done the live stream ones, we'll come back to the ones that are coming through the week that are not anonymized. So hopefully that will make sense. Obviously, I'm trying to incentivize people not sharing personal data. One of the reasons being you shouldn't have to put your life onto the internet to get a sensible answer. It's not necessary. Um, what else do I need to say? It's not, yeah, not legal advice if I've not said that already. So I'm not even a lawyer. Harrison will are, but yeah, it's just we're here to be helpful. Basically, we appreciate it's very difficult to get a solicitor on your case. We're hoping just to kind of give information that's useful because in some cases, a bit of information will be enough to get your situation sorted out. And well, a bit of information and making a complaint usually does the trick. And bit of gossip from me this week. I'm going to share my screen because I get the right one. So you may recall if you've watched the last couple of weeks that oh, I pressed the wrong buttons here now. You should right. You should be able to see an Excel sheet, hopefully, if I've just shared the right one. But I'm going to unshare now because I'm a bit nervous. So I'm going to share the right one again. Yeah, I've been FOIing every single council in the country to see what their average waiting times are on housing register for homeless applicants. And there's a reason why I'm limiting it to homeless applicants because it, people who are on the housing register under normal Part 6 or transfer, how long's a piece of string? There's no kind of, there's no real kind of way of using an average. But for homeless households, because there is more of a rush, you'll tend to find that these averages are much more accurate. Now they're not. In no way is it foolproof. It does rely on the council and understanding my question, and it's a pretty simple question. What's the average waiting time? But you'd be surprised how many basically how many councils don't understand that question. I have to go and clarify and say it all again. And a few councils most councils respond with very little effort because this is stuff they should be recording anyway, really. But a few councils kind of just give me nonsense stuff. So I have to kind of go back to them sometimes. But yeah, basically, at some point, I'm probably going to make a nice colourful map of England and kind of just kind of colour code it. You'll notice the London councils are the worst for waiting times. It's in days unless it says otherwise. So Waltham Forest, nearly 5,000 days if you need a 4 bed. Some councils don't have 5 beds, and some councils have bed-sits, which does change things sometimes. What was the worst was there's one which is 39 years. Yeah, Hackney. If you need a 5 bed property in Hackney, you're going to be waiting 39 years. But you'll notice, and the reason this is really why I'm doing this, some areas it's not very long at all, relatively speaking. Blackburn, if you need a 1 bed, average is 78 days. There's another one, yeah, Cheshire East 71, Wychavon District Council 74. So part of the point of doing this exercise is that there are people who, and I will obviously, these are just kind of drip feeding in now. So there are about 300 odd councils in the country. So each week I'm going to add to it and I'm going to do a big kind of spreadsheet at the end of it all. But basically, there are various circumstances that people might be in where they can approach any council. So they might be there fleeing domestic abuse or something. And it might be a choice between, for example, fleeing to Waltham Forest or fleeing to Blackburn, and it doesn't make any difference to you. Well, actually, if you know what the average waiting times are, you'll know you're that much better off in Blackburn if you're going to make a homeless application than you would be if you went to Waltham Forest. So that's kind of, that's the kind of purpose of it. Yeah, and there's a LGO case today which is a little bit interesting. If I just share the right screen. So it's a Sandwell Council, which I think is adjacent to Birmingham, maybe. I could check, but never got around to it. Karis, can you see an LGO page right there? Is that I'm sharing the right page, yeah? Because my system doesn't actually show it. So yeah, Sandwell Metropolitan Borough Council. It's a domestic abuse case involved in a family. So you've got two brothers, I think it is. And the guy basically approached. He was sleeping in his car, having fallen out with his brother, and basically, I don't think he used the word domestic abuse to start off with. So he said yes. So there was a feud with a sibling, and then they kind of explained that what else happened and kind of the law and stuff. There's a few bits which I thought would be generally interesting to people. So this one here, so paragraph 31, it just kind of gives an example of where you can make an out of time complaint to the LGO, because normally you need to get to the LGO within 12 months of you becoming aware that there was an issue. But in this case here, because he'd sent an email to the council saying, how do I complain or how do I challenge it? And then got back to him. And because he had some mental health issues during the period, the LGO basically said, yeah, we're going to use our discretion to treat it as a late complaint. So that's one bit that's interesting. There's another interesting bit here, and I have only scanned through this, so I might be misreading it. So do read this for yourself. But basically, when he was offered interim accommodation, it seems that the council made out like it was really expensive and he couldn't afford it. And actually, councils can't do that. They need to make affordable accommodation available to people. So I think he was working. So if you're working and you can't claim housing benefit, or you can't claim housing benefit for another reason, the council's duty still applies to provide suitable accommodation or make it available to you. So yeah, and again, there's just some other kind of general sort of stuff. There's another one which I thought was interesting. Yeah, it just kind of makes the point that the threshold to accept an application, as in there's reasons to believe he might be homeless, it's a low threshold. So the information the council had about Mr. X in September 22, as in I think that's the bit which refers to the feud, and that he was living in his car and met this threshold. So because they initially tried to say, well, he can return to the home, that he owns it, therefore he can return, but that again didn't kind of take into account the reality of it. Now, he didn't get a lot of money for it, and I guess that was because the period he was left homeless was quite short. So, yeah, again, I've not fully got my head around it, but so he only got £800, which is quite low for a domestic abuse case. But you can read it for yourself and see why that was. So yeah, might be interesting to you. So let's get on to the questions. Any gossip from? Sorry, I haven't even said hello yet, Harrison. Will, hope you guys are doing all right. I know Will's typing away there furiously.
I'm fully attending now.
Cool. So yeah, any news from you guys at all? Any gossip at all from the week? If not, we will. I was thinking when we get closer to this this end of section 21 kind of situation, we would do well to kind of focus in on that, just try and get our heads around it before it comes out, so we can kind of give some people some tips, because my guess is there will be something in there which councils will misuse, a bit like telling people to wait until the bailiffs come. I'm sure there'll be something in there which councils will try and use unlawfully. So we do well to kind of keep on top of that, really. So nearly there. Right, first question. I have some good questions coming on the channel this week. Let me share the right screen. And just for those who just joining, if you put your question into the chat and make sure it's anonymized, we're going to do this first little run of questions from the week, but then we'll get around to it. And also, if you haven't already, do give the video a like and a share. Not share. I don't think you can share it, but yeah, subscribe if you haven't, all that sort of thing. Just helps with the algorithm. Anyway, so first question here. Let me zoom in a little bit so you can see it and collapse that. So, what if you are awarded a sum from the ombudsman and you're not yet rehoused? Can you protect compensation awarded by the ombudsman whilst waiting to be rehoused, so it can be used to help with the move and getting flooring and not getting swallowed back up into the council and rent? Otherwise, it's not compensating your expenses and trauma. Can it be put in trust? Is if there's a pre-existing personal injuries trust? So, interesting question. I don't fully know the answer to this, but my guess here is that the amount of money you're going to get from the LGO is unlikely to really make much of a difference in terms of, like, you're not going to go over a threshold suddenly that you can't kind of get housing benefit or something. The biggest LGO compensation claim I ever saw was 27 grand, and that was for like years and years where a wheelchair user had basically been left in unsuitable accommodation. So we're looking, typically you're looking at a couple of £1,000. So I don't know this for sure, but I don't think it's going to be something which really changes much, about your situation and what you're eligible for. If the council tried to say, well, we're not going to help you with the first month's rent or something when they normally would do, then I think you'd probably complain about that as well. But yeah, so I don't think it's going to make much of a difference. I appreciate in some sectors you look at tens of thousands of pounds. I don't think you will be within the homelessness stuff. So yeah, that's my answer. Karis or Will, anything to add or subtract from that answer? As far as you know.
Um, Nothing much, but I can't quite see. It doesn't quite make sense to me, the question. I may be missing something because if you want to protect the compensation from being paid now, as it were, because you think it'll be swallowed up by debts or council rent, they'll set it off against rent arrears. The problem is you've either got to pay off the rent arrears before you get the money or have the same problem at the end of the day. And if you've got the money to pay off the rent arrears, it shouldn't be a problem. But I think the simple answer is no, you can't protect the compensation in that way, because if you owe the money, you owe the money, and the council may be entitled to say, well, we'll give you the money less any money you owe to us. That's just my thought,
Yeah.
but
Yeah,
doesn't add a lot to what you said.
Yeah, the only time I think so let's say, for example, is it 16,000 like threshold and housing benefit? So if you've got 16,000 worth of saving, you can't get housing benefit, something like that. If Shannon was here, she'd know. But yeah, so basically, yeah, that I guess that if you've got 20,000 pound compensation, then you might then have to essentially pay for your temporary accommodation costs whilst whilst you're waiting for the money to go down. But yeah, so but I don't think it's going to be an issue, is my answer. If we find out anything else, we'll get back to you about that one. So question 2, when complaining about 2 or more council departments to the local government social care ombudsman about one set of circumstances in which all were involved, would you recommend complaining separately about each department involved regarding the parts of the matter which relate to them, or making a single complaint about the entire matter and therefore all departments concerned be more appropriate? So this is a really good question. I think actually both would have kind of pros and cons. The positive about complaining about it all together is, yeah, I mean you're going to get it dealt with as a full complaint, kind of all together, and so in one sense there's going to be less kind of shirking responsibility. There's going to be like more about kind of a single council response. I think the downside is that could probably take longer. So you're more likely to have delays to the complaint because the social service department says, oh, housing haven't done this yet, and so we can't respond. So there would be, I think if it was me, I probably would make 2 separate complaints, or 3, or however many are necessary, and kind of isolate those kind of different departments. But I don't think it would make too much difference if you did it all as one. That would be my kind of thinking on that one. So sometimes you'll make 2 complaints about, it's effectively 2 complaints about the same department, so about housing, for example, and sometimes they'll try and take it as one complaint, and actually that's not in your interest. If you made 2 complaints separately and there's 2 separate timelines going on, you don't want it to be kind of amalgamated, because that's likely to lead to a delay, because one thing probably happened at a different time from the other. So yeah, I think that again, that's probably my approach, would be deal with it separately. And again, usual sort of stuff I talk about in terms of involving counsellors. So there will be a counsellor who covers social services or adult services. There'll be a counsellor who covers children's services. There'll be a counsellor who covers housing. There might be a separate counsellor that covers benefits, housing benefit, that sort of thing, or that kind of, yeah. In Bedford, it's kind of, I think, all under one roof in terms of housing and stuff, but other councils will be structured differently. So kind of involving them all and just kind of, keeping them up to date with what's going on, because I think, that just kind of maximizes the amount of accountability and probably maximizes the amount they're reasonable as well. One of the questions I plan to ask in Bedford Borough Council's next housing committee is, does the council have a policy to always not uphold the first stage complaint? Because that seems to be the case, to be honest. I'm sure they're going to say there isn't a policy, but then we're going to say, well, why is it that all the time they don't uphold the first stage complaint and they do then uphold the second? So yeah, that's my answer for that one. Karis and Will, anything to add for that at all?
I've got a little bit to add. I I would say I mean, the advantage of making two complaints is that it keeps it simple and stops it getting too complicated, and maybe means you can get it to the people that need to deal with it. But the problem is, and this is something I always try to work away from, is that the council departments, it's the council as a whole that owes the statutory duties and is supposed to provide the service. One of the things that council staff tend to do is say, "Oh no, that's not us. You got to go down go and ask somebody else." So if you ask housing to arrange a Children Act assessment, they'll say, "Go and ask them yourself." Whereas really, it's the duty is on the council. So I would say treat it as a complaint about a separate service failure, which is primarily addressed to the department responsible for that service, but make sure that it isn't a complaint about the department as such, but about the council as a whole. Because, say, housing staff in the housing department have a duty under the Children Act to make a referral where appropriate, and also to make a referral to adult social services. So, but you could say, well, my complaint about not getting a Care Act assessment is that when I asked housing to do it, blah, 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 and when I asked social services, blah, 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 but not to say that it was each department that failed.
Yeah, cool.
That
Thanks,
makes
Will.
sense.
There's I'm going to go slightly off piece. There's a question just come in on the live chat which relates to this kind of question. So I'm going to just jump ahead and do that one now because it's all kind of part and parcel of the same conversation. So number 3, if the LGSCO makes a draft and there are issues not addressed, how do you get them to address them during the window between draft and submission when it's within the time frame investigating? So yeah, basically when you get through the council's complaints process, you've exhausted it, it's still not good. So you go to the local government ombudsman. They'll kind of information gather to start off with. They'll contact the council, but before they reach a final decision, they'll send you a draft decision. Now, in my experience, not a lot changes between the draft and the actual final decision. I can think of cases where I was like, well, there's an important issue here that's not been addressed in the draft, raised it, and then it still didn't come into the final either. So I think all you can do is basically just make sure you're raising it, but kind of take a moment to just stand back from the situation for a moment and just kind of work out, am I right? Is the complaint sound? Is what I'm saying correct? And also just bear in mind that the local government ombudsman has a remit which they can't really go out of. So if you're talking about decisions that were made by the council, Section 184 decisions, then there's not a lot they can do about it really. It's kind of a separate issue. If they'll say that you can go and challenge it through the court process, so they're not going to make a comment on it. And they're not fans of kind of zeroing in on a particular housing officer and kind of going after them, even though that's sometimes warranted, quite frankly, because there are some wrong ones out there. But so I think, yeah, I guess what you want to do is probably check. You can have a conversation with the LGO investigating officer. My experience, they're nice people, and just say, look, I've kind of raised this issue. You haven't included it in the draft. Why is that? Am I not understanding something right? And hopefully at that point they'll say, yeah, I've heard what you're saying, but I don't agree with it, or I heard what you're saying and it's not in our remit. So you might kind of get an understanding that way. But I think, I had one decision 10 years ago where I challenged the LGO final decision and I still lost. And I was like, I was kind of a bit disheartened by it, but that's how life is sometimes. So I think that's what you want to do is try and they are contactable on the phone, and you can just kind of explain the situation and just try and stand back and listen to what they're saying is probably my advice, because by this stage you're already very invested in this. You're probably very emotionally invested as well, because presumably there are some failures which kind of had a very big impact on you, and you've got to try and separate that out from that, because otherwise you kind of get fixated on things which the LGO might not be able to make a finding on. Because the other thing to say is that on certain things the LGO won't be able to make a finding at all, because there isn't evidence either way, or kind of evidence either way isn't kind of definitive. And so the LGO might make kind of say, well, do you know what, I genuinely don't know what happened there, based on the information. And then there's an example of it here, so I'll just add this in as well. So specifically a personalised housing plan, in which private rental scheme was which was not affordable. So it might be that the LGO would probably be able to make a finding whether there was some kind of assessment of affordability, but the LGO won't necessarily be able to say that they agree with the council's position on it. So you'll see some LGO decisions, they kind of say, well, the council didn't, they followed the right process, we can't make it, we can't sort of say whether their decision was right. And potentially affordability might come under the kind of the stuff you'd normally take through the court process to challenge. So that would be my kind of speculation there. But I would say put it to the LGO investigating officer and just find out what they're saying, because they might tell you straightforwardly in a way you can understand. So yeah, but keep going is probably what I'd say. And it won't all go your way, unfortunately. As I say, there are things which you're probably right about, which the LGO isn't able to or doesn't kind of uphold. So yeah, but well done for getting that far in the process. There's another question from the week that relates to LGO as well, so I'll kind of keep going on this theme. Karis and Will, feel free to interrupt me if you want to add anything to it. So would it be in someone's interest to go to the LGO after complaints to the council about non-priority decision last November, where the law was breached very clearly if the Section 202 right to review was not made at the time due to lack of mental capacity through vulnerability and sourcing own private rented accommodation? So we saw that Sandwell case I mentioned at the beginning where an out of time complaint was considered, but again, this is I don't know if it's ever set out in writing what the LGO can and can't do, but effectively the LGO would not be able to make a comment on, was the non-priority decision the right decision. I think the LGO can basically say not enough inquiries were made, or the homeless application wasn't triggered when it should have been, or interim accommodation wasn't triggered when it should have been. But in terms of like unpicking that non-priority decision, did the council consider the information it had correctly? I don't think that they can do that. I've seen a little bit of kind of mixed stuff with it. So I've seen some LGO, I'm pretty sure I've seen LGO kind of make a judgment on whether the council made enough inquiries, but I might even on that, I might be making it up. I don't know. So I think the answer is probably, is it in someone's interest? Well, there's nothing to lose other than your time. So you can just make the complaint and just see what happens. I don't know if they still do it. They used to do like a phone advice line. You could ring the LGO up and get kind of someone to give a kind of a bit of info on the phone. So yeah, I think you can go after it, see what happens. Worst case is it doesn't get upheld and you kind of lose the time that you made to get that far. A lot of the time the LGO will say in the decision they publish, we didn't pursue this complaint because there's no kind of there's no reason to, really. There's no kind of merit in doing so. So this might be something which they say quite quickly. No, we can't look at that. I don't know. So yeah. And just sorry to the live chat for a second, guys. So yeah, there was a question in there just in the first person. So just can I say again, don't put personal data into the chat. You just ask it as if it's about a hypothetical person. So that is all of the questions that have come in through the week that were anonymized. We will now get into the questions in the live chat. Appreciate that I've already actually done one. I've now lost my screen. Hold on. Let me just come out there for a second. Hold on, guys. Right, let's just have a look at what we've got. So, okay. Right, there's first thing, someone saying it might be a silly question. There is no such thing as a silly question in this sector because there's so much misinformation out there. There is no silly question. You can guarantee any question that might seem silly, you're asking it because some housing officer somewhere said it. Right, I'm just now struggling to juggle my screens here. Bear with me. Yeah, there we go. Yeah, cool. Right. So, yeah. So it might seem a silly question, but if someone is homeless or sleeping rough, registered for benefits at the job centre, is it right they've been having council tax taken from their benefits? Okay, so my guess here is we're talking about council tax debt that's been recovered in the benefit payment is probably what's happening. If that's the case, then yeah, I think that's probably possible for council tax to do that. I'm assuming there's some kind of baseline limit at which it's kind of you're under a subsistence for that, like under severe hardship, that kind of thing. I don't know what the threshold is. Again, Shannon would probably know that because she knows a lot about DWP stuff. So yeah, I think you can potentially write to council tax, say, look, I'm homeless at the moment, sleeping rough. Can you stop taking the money out for the time being and kind of delay it or something? I don't know how willing they'd be to hear that. Karis or Will, do you know anything about this kind of situation? Karis?
Yeah, sorry, I was just gonna say I would get debt advice even from the CAB because they might be able to put like it's called a breathing space in place. So it might freeze the debts that are being taken, but that's something you should definitely go and get advice for.
Yeah, cool. Yeah, I mean,
They
yeah,
could look at
it's
all the finances that are being taken and phone the DWP on your behalf.
yeah, that sounds like a sensible thing. I mean, I think it's something well outside my area of knowledge, but it does seem to be something which get a bit of free advice from someone like CAB. I mean, check out, like, if there's not a CAB that does debt advice in your area, do check out. There's usually at least one charity that does it. So do check that out and just see what they say. So yeah, cool. Cool. So hey, what cheese face? So someone just asked a question. Uh, was also wondering if one could find out how many homeless people are waiting in certain boroughs. So yeah, you could do the same thing that I'm doing basically and do like an FOI. In fact, one council sent me how many people on the waiting list rather than the average waiting time. So I've gone back to them saying that's not what I asked for. So you could do it that way. I'm just trying to work out. There is a lot of information on the government homelessness live tables, but they don't have the number of people waiting in certain boroughs. But I would say that because different boroughs operate the waiting list differently, certainly if you're looking to compare different areas, it probably wouldn't be it'd be like comparing apples with oranges because some areas kind of, won't, they'll basically kick people off the register unless they kind of hit certain criteria, whereas other boroughs, they'll have people who are on the register but basically dormant for years and aren't really bidding and probably aren't homeless, but the council doesn't bother, kind of checking it. So yeah, you can certainly do FOI, freedom of information. You just literally Google freedom of information plus the council's name. You'll then get their email address and you just send the thing to them. They've got 20 working days to respond, but as I'm seeing with a lot of councils, they're doing it pretty much straight away for information that they've got at hand. And they will have that at hand. They'll definitely have that number. So yeah, so you could do that. And yeah, again, I don't know. I would say the average waiting times is probably a better indicator because the number of people on the waiting list won't tell you much other than there might be 200 people on there. Well, okay, how quickly are people getting housed? That's probably more useful. So cool. So just more just more people there putting personal data on it. Just going to take that off. No offense. You just rephrase it in the anonymously. That'd be awesome. As in make it out like it's about someone else. That's what we're really doing here. So you notice if we go back here, these are good questions. Just to explain what we're talking about. I know it's a bit of a weird thing. So what if is a good way to start one of the questions. So what if you are awarded? So there's no personal data in there. Do you see what I mean? There's a difference there in terms of saying, oh, I've been awarded a sum of money, rather than what if you were. You're going to get a better answer this way, and you don't have to divulge anything. So um, So, okay, this is interesting. Still on the kind of complaint theme. Oh, wrong button. So, Friends Council refusing to accept stage one complaint as it been more than 6 months after homeless application. It doesn't state this on the website. Can my friend still? Yeah, I would say I've never come across a council policy that's only 6 month window for complaining. The LGO is 12 months. So basically, what you would do is complain to the LGO, and you're within 12 months of it happening. The LGO would probably then go back to the council and say, what you're doing, you need to, if you don't kind of respond to this complaint, then we're going to get involved now. And the council probably won't want that. So they probably would then go with it. So yeah, as I say, I've not seen that. Every council complaints policy I've ever seen will always say 12 months, and the LGO says 12 months as well. I always thought that was kind of like some sort of statutory requirement, but maybe it's not. But yeah, so I think if the council's refusing to take the complaint, really they should be saying in that refusal that you can go to the LGO, because when a council responds to complaints, it should have to tell you what the LGO is, that you can complain to them and actually give the LGO's contact details. So interesting one. Yeah, that's all I can probably suggest on that one. So yeah, again, Will and Karis, feel free to chip in. So yeah, and a good question here as well. There's a lot of different people asking about complaints in LGO this week, which is cool. So as a lot of this is time sensitive, can a judicial review be better than an LGO decision? And are you able to do both? So yes, you are able to do both. And this is an interesting topic, actually. We could probably go into a bit of detail tonight. So the the kind of court process, again, will only be looking at certain things. So, if a member of staff was really rude to you, courts probably don't care about that. Courts will be looking at, was the decision right? Was it made in the right time frame? Did the council follow the law, basically? So, and the problem with the LGO is that it could take a year, could take 18 months to actually fully resolve, by which point there's no point to you because you've been homeless for 18 months. So the judicial review process, the good news about it is that it is dead quick. The bad news is about you've got to find a solicitor to do it. So yeah, but if you can find a solicitor to do it, then you should absolutely go down the judicial review process. And it might be at the end of that, there's still plenty to complain about as well. So and I guess potentially, I don't know if you'd be complaining and I don't think it'd be exactly the same thing you'd be complaining about that'd already been for judicial review. But I'll give an example in Bedford. I'm just thinking off the top of my head. So I had a non-priority decision for a guy who had been alcohol dependent, heart attack, lots of stuff going on for him. And the council officer said it's a lifestyle choice, basically he's not in priority needs. So I challenged it through effectively the court process, section 202. So before it got to court, so as a layperson, I could do that. Got it overturned, got him in priority needs. But then I also complained about the officer saying that it's a lifestyle choice, basically, because it was, in my mind, it was something that housing officers shouldn't be saying. So and that got upheld as well. So yeah, that's one example. There's probably plenty of others. Again, given that this is Will and Karis's bag, what else would you say about this one in terms of pros and cons of each kind of route?
Shall I just jump in there? The big con of judicial review generally is that you're really only looking at very precise breaches of statutory duty or something like that, and looking for a very specific outcome. You can, in theory, claim compensation in judicial review, but the admin court is really reluctant to go down that route, and so it's very unusual, unless there's sort of serious breaches of human rights or something, for damages to be dealt with. And also there's the issue of whether local authorities are liable for damages for exercise of public law duties, which generally doesn't give rise to civil liability. So if you wanted to claim compensation and you also wanted the general overall experience which you had to be taken into account, you're better off with the LGO. But were you saying, Mike, because the thing that worried me was that the LGO might use the fact that it had been the subject of judicial review proceedings as a reason not to get involved. So, no, this was something that went to court. But if you say, well, we only went to court for a very specific thing, maybe you could still make the complaint.
Yeah, as I say, it's interesting. I mean, I've never seen it set out what exactly the LGO can and can't do, but I assume there is a document somewhere that does that. I might look into that. But yeah, so the LGO is interested in kind of stuff outside the law altogether. So, was the housing officer really rude to you? Did they give you kind of wrong advice or whatever? And they'll be and they're more concerned with, when you approach the council, did the council accept a homeless application when it should have? And that doesn't matter whether you're in priority need or whether you're owed a housing duty. Did it literally accept an application when it should have? Did it start the relief duty when it should have? Did it give you a PHP when it should have? But then the content of the PHP itself. So if the council issue you a PHP, then the LGO would probably have less to say about it. But you might then challenge something within the court process, suitability of accommodation offered or something like that. So trying to think. Yeah, it's an interesting one. I probably could say more about this. Trying to think how else to kind of phrase it. but yeah, so again, you'll see it a lot in the LGO decisions. You know, that the complaint includes something about you know, the decision was wrong. You know, I was in priority need, but the council said I wasn't. The LGO will say that was something you should have taken through the 202 process. You know, unless you had a good reason not to, and so it won't go further than that. But as I say, I think I'm trying to think there might be things within there where the LGO does effectively kind of unpick that sort of stuff, but it's more about, yeah, did those kind of stages that are within the homeless application process, were they done in a timely manner? Were the right records kept? Was, you know, yeah, all that kind of stuff, I guess. Was the right advice given? You know, was any advice given? Um, was there a policy at play which kind of led the council to break the law? That sort of stuff, really. I'm going to give it some thought this week and see if I can phrase it better than that, because I think I can phrase it better than that and kind of distinguish between the two. So yeah, yeah, Karis.
All right, I was just going to say that the judicial review is quite technical. So who you have to look at who is taking this. Whereas the ombudsman is for everybody to complain about, whereas the judicial review is a technical legal issue. So someone could run into real problems with what they're saying and what the grounds are, and if they don't get it technically right, it's going to be it can be thrown out on technicality. So think about who's putting it together.
Yeah.
Plus, you've only got 3 months to go for a judicial review at the very most. That's another thing. So you've got to act really fast to get a judicial review.
And I mean, all I can say is my own experience. And as I say, the reason I can say this is I've challenged Bedford Borough Council consistently for more than 10 years now. And it definitely, yeah, within a couple of years, it got to a point where us, you know, just so the organisation I set up with John Allen, when we got involved, we'd get a good outcome. We never, so we until recently, Justice had never taken a case down the kind of legal route to get a solicitor involved, because we'd always managed to get good outcome by complaining and, you know, bringing up councillors and just basically saying something wrong's happened here. The problem with that for people who are, you know, just lay people is this is the first and only time you've probably ever had contact with the council. And it was only until we'd done it for 2 years that we started to get that reputation of, okay, oh shit, you know, these guys are involved, we better actually do something properly. So for any professionals listening, you can absolutely do a lot of good stuff with just the complaints process going to the LGO. But for a lay person where this is your first time doing it, the council will just assume that you're going to give up, basically, and a lot of the time they're right. So it's much more difficult to get a timely response. You know, as in, there were times when I ring up the head of service and say, you know, you've got a problem, and because you know, the head of service knew I was pretty right most of the time, they took it more seriously than if, you know, just a lay person did. So yeah, if that's helpful, good, useful information, but I guess it gives you a bit of kind of idea of how the two different processes could work. Whereas I would imagine a solicitor writing kind of a coherent letter, pre-action letter or something, almost certainly would get a good outcome with the council, because they do, would fear that they're going to get judicially reviewed. Okay, so I think there might be, don't know. I think there might be a question here which might be related to a specific housing allocation scheme, but let's have a look. So let's piece this one together. After 6 months homeless, and are other points such as a hardship available once full duty and homelessness accepted? Okay, so I don't. If that person could just maybe expand on that a little bit, I'm not quite sure. Not quite sure.
Allocations, doesn't it?
Yeah, the second part's about allocation, which we probably answer. So, overcrowding points awarded to those in temporary accommodation when beyond. Okay, so the answer is probably not, because councils shouldn't be putting families with children in B&Bs for more than 6 weeks anyway. So they wouldn't have a policy saying, yeah, you're going to get extra points, because that's almost saying, when we break the law, you know, you'll get extra points. That would be a bit of a weird thing to do. So if you are a family with children in a B&B type of temporary accommodation for more than 6 weeks, complain. If you look on this YouTube channel, I did a video a few months ago which kind of it looked at the LGO and basically how the LGO recommend between £100 and £200 per week over that 6-week limit. And there's another video recently about how the best way to make a complaint or something like that, which again I kind of just explain the steps that you can do to maximize the chance of your complaint being successful. So so in terms of the individual point system and stuff like that, it will just depend on the council's policy, and every council's policy will vary quite a lot between different councils, so it's not something we can necessarily give much use or much help on this channel, in this setting. Oh, do you know what I think? Okay, so hold on a sec. I missed the first part, but that might make sense why I wasn't following it. So what if once homeless application accepted and fully accepted, is it true that council does not have to award 100 points for homelessness because one is on different points? But yeah, okay, so yeah, so that all makes a bit more sense now. But yeah, the answer is the same, unfortunately. Points, just, you know, some councils don't have a point system at all. You would have to Google your council's name and then the phrase housing allocation scheme. That will then take you to the policy. It might be called something else. It might be called housing register policy or choice-based lettings policy or something like that. But it's their legal. They legally have to have a policy, and legally it has to follow some certain rules. But points and stuff like that, it's just going to vary from council to council. So you'll have to look at the nitty-gritty of what the policy says. It's not unusual for councils to break their own policy. So you know, do go digging around in it, because yeah, I would imagine a lot of housing staff have never read their own policies on this sort of thing. They're probably, you know, kind of making stuff up as they go sometimes. So do have a little look. And yeah, if you can see that, you know, you meet certain criteria, you should be getting X number of points or X band or whatever, then it's absolutely worth challenging the council on it to get your banding kind of reviewed. So let's go back to the ones from the week. There's a couple that have come in through the week that are not anonymized, which is yeah, kind of I'll leave till last. So yeah, so now would be a good time to start putting any final questions on the live stream, guys, if you're watching now. So number 10, would it be in someone's interest to go, we've done this already, haven't we? Hold on a sec, I just copied and pasted the wrong thing. So this one here. So yeah, 2 questions. So I'm a single man with disability, entitled to Studio 1 bed, made homeless application, having assessment in a week's time. What if they offer me a studio which is too small that I can't put my stuff in it? So this is an interesting question, actually. I don't know the answer fully. If it's equipment related to your disability and, you know, reasonable amount of stuff, then yeah, the accommodation will need to be big enough for that. But if you've got 2 garages worth of random stuff, then I actually don't know what the rules are. You know, my guess is, well, I'm pretty sure they don't have to house that sort of stuff. I'm not quite sure what limit they would put on amount of belongings. As I say, if you just happen to have loads of stuff, you've got a grand piano and, you know, bandsaw and all that sort of stuff in, you know, that you need to, I just don't know that they're going to do it. But it'd be interesting. It'd be an interesting question from the point of view of the council's duty to protect property is absolute. So if you've got a boat, well, I don't know. They need to protect the boat, but I would imagine that they're going to set a reasonable time for you to downsize and sell stuff, basically, is my guess. But I don't know. Will and Karis, you ever come across that situation before, where they've got, you know, you've got so much, yeah, stuff that isn't related to disability aid adaptations or something that's not going to fit into the accommodation they end up in?
I haven't come across it, but it raises a really interesting legal question, which I'd really be interested to explore further, and because it makes me wonder why I've never come across this. But if you think about a homeless applicant and a homeless family, then each family must, in theory, be allocated what you might call a reasonable amount of presumed belongings. Because if I said, I want my, I don't know, I happen to have Europe's biggest collection of Pokemon, and I need like 3 rooms to put them in, and people would say, well, I mean, that's not reasonable. But if, on the other hand, I had some other thing, I don't know what, there comes a point where the question is, where do you draw the line where you say, well, that's just daft, you know, you can't carry all that stuff around. I mean, I don't know how much stuff we all have. I mean, how many changes of clothes should one have? You know, and how many toys should children have? Because that's, I don't know about you, but having had two kids, I've recently had to, you become a bit of a hoarder because I've got all sorts of, my kids are in their teens now, and nearly, I've got loads of sort of things that they had when they were 2 or 3, and I can't bear to part with them. But what I have done, I've had to do a couple of trips to the skip, but it took a long time, and I could have found that I was faced with a dilemma there. But legally, it's interesting that a judge must at some point have been faced with this, where somebody says, and also there's that thing about psychological attachment. You know, the people say, I need a dog because it's a comfort dog, and I may need my belongings because they have, you know, I'll get anxiety attacks if if I'm parted with these things that remind me of something. But a really interesting question. I mean, maybe it's in the Encyclopedia of Housing Law there, but I haven't come across it, I'm afraid.
I would have thought it would have come up in hoarding cases, you know, sort of genuine
Yeah.
hoarding cases actually, because you know it might seem like rubbish to us, but it's important to a person potentially. And so I wouldn't be surprised if there is some kind of case law on it. Karis, do you know
Yeah,
anything about this one?
into it.
What, any thoughts?
Well, I would just instead of using the law, you've got the duty to protect belongings, advocate for why your stuff is important for you
Mm,
instead of
Yeah,
like, because if it's reasonable and it's important to you, each and every item, you can just say along the lines of hoarding and the mental anguish about losing it. It belongs to someone too important to you who's no longer here, for example. It would be hard to get rid of that stuff. So that
yeah,
advocate for the reason why you would want
yeah,
to
yeah,
keep
yeah.
your things.
Yeah, that sounds helpful.
yeah.
Cool. Again, if we ever come across some cases on that, we'll try and remember and bring it back to the live stream. Um, and then final question we've got at the moment, unless there's another one that comes in the live stream. Let's get rid of that for a second. So this is a long one, and oh man, I'm going to try and be nice about it, but it's difficult. Like I don't know, it's a difficult situation. This person's knowing. So hello, I wondered if you could tell us whether we could come back from our situation. We wanted a house for a long-term home. We recently found ourselves about to be homeless in Feb. Court done date to leave 1st October. Magenta Housing Association offered us a 3-bed flat 2 weeks ago. I said being in a flat would only further my anxiety and make my mental health situation worse. So the housing association made a note, no flats, and this reassured me. Yeah, a week later, I was offered another flat, same housing association. Yet this time, I got in touch with the housing officer, and they have now deemed me intentionally homeless after pressuring me for answers that day on a new flat. I asked if I could call back tomorrow. He said no, has to be today. Under so much pressure, I refused after saying I felt I was being backed into a corner, and he asked if I understand. I said not really. He was like, okay, I've got to go. I feel like I've been promised my family will be okay, and now we're in this awful situation. Is there anything I can do? So there's a few bits of the code of guidance I'm just going to dig out in a minute. I mean, I guess this is kind of why I think any housing professional will always kind of strongly suggest that people accept the offer and then challenge the suitability of it. Now, it is possible, you know, if you had like, you know, very strongly and detailed letters from a psychiatrist saying that, you know, why it is you need a house rather than a flat, but it would need to be very kind of very specific and kind of, you know, without that, I think you're going to struggle to win that argument. Now, potentially there might be an argument to be made or a defense to be made. I'm going to get the Homelessness Code of Guidance up if I can operate my mouse properly. Which basically talks about having a reasonable amount of time to make a decision. Now, can't even remember what chapter it's in, and I can't remember the text that it uses. So I'm trying to search for it on the PDF. Just bear with me. Will and Karis, have you got anything to say at this point? I'm going to just try and dig this stuff out whilst you're talking.
Hmm. Harris, do you want to say anything before I jump in? Because at the expense of sounding unsympathetic, I'm going to say a few things because I think this is a good example of problems you can get into by refusing stuff, and also to with no disrespect to the person asking the question, because it's very common that you don't see the problem coming until it's got to this stage. So problem number one here is you speak to a housing officer and say you don't want a flat, and they make a note that says no flats. that doesn't mean that they made a decision on behalf of the housing association that you will not receive, that flats are not suitable for you. They may have just made a note that you said you don't want flats, and they may have gone back to their manager and said, and the manager said, "Oh, don't be stupid. You can't agree to that." And so next time they spoke, they said, "No, you got to have a flat." You can't. It says, I feel I've been promised my family will be okay. Well, I don't see any promises in there. I see somebody, maybe a busy housing officer, saying something that was misleading. And the other problem is, if you think something's unsuitable, I mean, this is and you refuse it. The danger is if you then get told you've basically that's it, game over, you're in this situation. So you're better off accepting it and then requesting a review. And also, I know I'm going to get, I feel bad saying this, but it comes up a lot. People say it will further my anxiety and my mental health situation will become worse. I hear this a lot, and it probably jars on a lot of housing officers because most people's anxiety will be increased if they don't get their own way. I hate to say that, but it's how it sounds. And also, your mental health situation. I mean, your mental health situation isn't going to get better if you get anxious. So you really need to be careful of bandying that about. I mean, I know you may genuinely have problems, and I apologise for that. But be careful of saying that because it can alienate people. And so, what I would say is I would always advise people if you get an offer and you don't like it, unless you feel you could never ever live there, and then accept it and request a review. And don't rely on anything that people say unless you've got it in writing. If they say, we recognise that a flat is unsuitable for you and you should only have an offer of a house, that's all right. But anything less than that, you haven't been promised anything. You've just had a conversation with somebody who may not even have been listening properly to what you were saying and just repeated, "Oh, no flats, eh?" That doesn't mean they're saying, yeah, I'm repeating myself. So I'm really sorry if, but this is sort of like an example that a lot of people, the thing that people say to me is, if only I'd realized this at the time, nobody told me this would happen. And so I'm sort of ranting a bit now so that people.
Yeah. I mean, I agree with you on all those points. Well, I mean, I think, yeah, I mean, I guess this, there's obviously a lot of so people kind of go through this process with a lot of misinformation, and so a friend might have said, "Oh, if you just hold out, and you'll get what you want," and you won't, you might not do. Sometimes kind of you take the risk and it kind of pays off. Other times it really won't. I mean, this is the bit I was just referring to there. I was going to read it, actually it makes sense. So 15.46 of the Code of Guidance. Secretary of State recommends that applicants are given the chance to view accommodation that is offered on anything other than on an interim basis before being required to decide whether they accept or refuse it, and before being required to sign any written agreement relating to the accommodation, for example, a tenancy agreement. Where housing authorities are making offers of accommodation outside their district, they should take particular care to ensure applicants have sufficient information about the location of accommodation and the services that will be available to them, and there are applicants and that applicants are given a reasonable amount of time to consider the offer before reaching a decision. So maybe you could advance an argument based on this, but certainly I would not be looking forward to making it if I was doing this on someone's behalf, because it's a difficult one, particularly if the council wrote to you saying, if you don't accept this, that's the end of it, then it's kind of difficult to really make the argument. But you could potentially say, well, I never had opportunity to find it. The problem you've got is if you said to them, well, I won't accept any flat ever, then that's the reason that you just rejected it. It wasn't actually because of the nature of the actual property that you've rejected it. And so I think this person is in a very difficult situation now. What option does that leave them? If they have a local connection to another local authority, they can approach there. I mean, they can approach anywhere, but it's pragmatically, it's just not going to work in this situation. But you could make an application to a different local authority, and if you have a local connection and kind of get through that initial kind of process, then they would make a decision based on whether you would be intentionally homeless. And I think they could still reach a decision you're intentionally homeless. So it might be that if you've got children involved here, then it's going to be referred to children's services, and children's services would have a duty to provide accommodation, but that, as we've said before on this channel, that is rough. That is camping out in the customer service centre of the council until they, refusing to leave, and then getting placed anywhere in any type of accommodation. It doesn't have to be suitable under the Housing Act. So that is an absolute backstop, last resort kind of way. So yeah, I think that's.
Could I just come back and say something constructive? I feel that I got carried away there, and I was sort of guilty of putting the boot in. I mean, and knocking you when you're down, and I'm sorry about that. What you've asked, what is there anything else I can do? And I would say yes, there is stuff you can do. Number one is, if they have found you intentionally homeless in those circumstances, they shouldn't have done, because unless they've treated their duties as discharged and then said they're going to evict you from your temporary, and then you reapply and then they find you intentionally homeless, what they should have done, based on the scenario you've described there, on the sound of it, is they say, we've discharged our duties to you, we're not going to offer you anything else because you refused a suitable offer. And then you go back and say, hello, it's me again, I'm homeless. And they say, well, you're intentionally homeless. Now, then you can challenge that. And if, taking your medical condition and everything at face value, if you can get medical evidence showing that you suffer from anxiety and stress, and that you were put in a position where you had to make a decision, and you genuinely believed that you'd been told you were only getting a house, and you got medical evidence supporting that, you'd be in a strong position to say it wasn't a deliberate act because you were mistaken and it was in good faith. And then, in addition to the Children Act, if you lose on the intentional one, the council still have a duty under section 190 of the Housing Act 1996 to help you get accommodation because you've got children or you're in priority need. So it's not, I mean, the Children Act comes into it as well. So there are further safety nets. So it's not the end of the world, although it may feel like that. So I hope that's a bit more positive. But there are things you can do and protections that you have. So good luck.
Yeah, and to just expand on what Will just said there. So in making a fresh application, presume this family is in priority need because they're at this stage anyway. So you're going to get 3 months in temporary accommodation pretty much before the council ends their duty under section 190. So that might give you time to kind of put something else together. There's just a comment there which kind of relates to this. They shouldn't discharge duty. They have to ask one more time to accept the offer, or they discharge duty. That's not true. I know why someone's saying that. It's because the wrong one. So in some housing allocation schemes, there will be refusals, and you can refuse properties. It's less common these days actually. Most councils now have a policy saying, yeah, you've got one opportunity, that's it, then we're done with you. But in terms of discharging the duty under section 193, there's not, it's not about having 3 strikes. It's not. It's just one. It can just be one offer. If the offer's suitable and you turn it down and you don't win that argument with them, then that's the end of that homeless application altogether. And there's just a question there as well. Sorry, Karis, did you want to come in on this one at all? Not sure if you're unmuted there or not.
Sorry, I would just add in to the emphasize on that you didn't fully understand or there's lost in translation, made a note on the file that you didn't want a flat, like Will said, that it's just a note on your file rather than a fully, this is completely laid down. Just make the note that you didn't fully understand the consequences and the loss of translation.
Yeah. Cool. Right, I think this is going to be our final question. It's bang on 8:30 as well. So what's the maximum length of time people stay in temporary accommodation? Could it be 20 years? Yes, it could. If you're in, I don't know, Lambeth or something. I've heard of people in London kind of being in temporary accommodation that long. But as we saw at the beginning of the video where I was kind of showing the average waiting times for people who are homeless, in many councils it's much less than that. So Blackburn, for example, 71 days average for a single bed. You have to get through the relief periods and stuff first. So you would have, the people in Blackburn would be generally, maybe in temporary accommodation for 4 or 5 months before they get an offer of social housing. And there may well be offers of private rented accommodation way before that. So those figures I actually shared at the beginning of video that it doesn't take into account the fact that some people will be getting private offers. But I think it's still useful. It is a useful kind of gauge of what the differences are in waiting times. So yeah, that's it. Thanks, guys. Karis and Will, appreciate all your time you're spending. Will, you're back on Monday, ain't you? And I'll be there if I'm invited. So yeah, we'll continue that. Karis may well be coming in on Monday as well. So yeah, and there's one other thing I just want to share before we finish. So there's an event coming up this is basically to anyone who is interested in kind of getting systemic change in their area. So there is actually another decent question there. Cheeseface, I'll come to it in a second. So basically, I think that's shared. So the public law project, I think that's the link I've just put in there. If it's you're gonna do it. Go on. No, it's not liking it. Hang on a minute. If I just do that, that might work. So yeah, it's basically low cost. If you're a grassroots organisation, you can actually get it there for free. Although it is like I do suggest you pay 20 quid. It's basically a series of online seminars, getting a whole bunch of different people who are all trying to get systemic change within various levels of government. So some of them are like central government, some of them changing the law. I'm doing a little bit in there about kind of influencing local government. Shannon's she's doing some stuff on co-production. So yeah, it could well be very interesting, and hopefully, I mean, I'll be learning stuff on there. I know in terms of the structure of councils and stuff and how we can challenge them better. So yeah, do check that out. And then finally, we are going to do one more question. Find the right screen. All right, there you are. Cool. Yeah. So, is the penalty for being found essentially homeless that you have to reapply? So, in effect, it's an interesting question. I mean, it's never supposed to be a penalty, but the penalty, in effect, is essentially going to be the council won't owe you that long-term duty. So the difference between Section 190, which is where you're in priority needs but you're intentionally homeless, the council only have to house you for a further sort of 2 or 4 or 6 weeks after the relief duty is all finished. So you total of about 3 months. Whereas Section 193 is, they have to eventually they have to find you suitable accommodation either in social housing or in the private rented sector, and that responsibility remains with them until it happens. So yeah, so sorry, just saying that. So in terms of Will's live stream, if you search for Will Flack Law, so Will, let's type it in there. So if you just search for this on YouTube, you'll find the channel. If you subscribe to the channel, you'll then get a notification saying it's going live. Will's got some very fancy technology that I don't have that basically gives like a countdown to it. So yeah, check that out. And yeah, check out. So Will, if you also search for Will Flack Law on Google, you'll get Will's website kind of blog, and there's a whole bunch of stuff in there, like lots of resources in terms of like learning stuff and whatever. So check that out as well, guys. But yeah, see you on this channel in a week's time. Hopefully see you on Will's channel on Monday. Will and Karis, thanks very much. Have a good weekend. And for those who are listening, hopefully this has been useful.
Yeah,
and yeah, just keep on going, basically. Take it easy.